Welcome to War Story Wednesdays. Today I want to talk about usury. Some of you may not know what usury is, so give me 10 seconds.
All set for 10 seconds, round one.
There's a concept in the law that says while it's okay to make a loan, you can't charge too much interest. If you do, it's usurious. It's not allowed. And California sets that interest rate, as a matter of law, at 10%. Now, there are exceptions to the usury law where you can actually charge more than 10%. And that's where real estate brokers get a lot of friends. Because if a loan is made or arranged by a real estate broker for someone else in expectation of compensation, the interest rate on that loan can be anything that the market will bear. And in this case, a real estate broker made a loan and the rate of interest was 15%. Now, the borrower defaulted on that loan and the lender foreclosed on the real estate. And then the borrower sued to have the foreclosure set aside and to get the real estate back. How come? Because the borrower said the loan was usurious. The borrower's claim was that the broker who made or arranged the loan was also the trustee of the trust that was the lender. And if the broker is also the lender, that's not made or arranged by another. The borrower also noted that the broker did not collect a real estate commission. Well, then it's not for compensation. And if it's not made or arranged for another in the expectation of compensation, then it's usurious. The trial court granted the real estate broker's motion to dismiss the case. The borrower appealed. The Court of Appeal looked at two of those issues carefully. First, with regard to whether or not the loan was made or arranged for another, the court said that it was the trust that was the borrower, and the broker was merely the trustee of the trust. And just like a trustee's personal assets cannot be used to pay a creditor of the trust because it's the trust that owns the asset, so here also the trust was the lender and was going to get the benefit of the interest, not the broker in his capacity as trustee. With regard to whether or not the broker received compensation for arranging the loan, the Court of Appeal said compensation doesn't have to be in the form of the payment of money, and that the trustee of the trust, the broker that arranged the loan, could receive the benefit from the trust and payment by the trust when the trust dissolved. And that was the expectation of future compensation sufficient to constitute compensation for making the loan today. And the trust was able to keep the property. There have been other cases where usurious loans have been made or arranged and the broker hasn't received compensation, or where the broker has made the loan himself and paid himself a commission on doing that. And in both those instances, the loan has still been found to be usurious. So if you find yourself in a scenario where you are making or arranging loans for someone else, you should check to be sure that you are actually right on the money, pardon the pun, with regard to making or arranging for the expectation of compensation for another.